Ladies and gentlemen, moving on, our next session is titled Family Protection Orders, the Vanuatu Experience from 2008 to date. And we have three speakers joining us from Vanuatu, and I will introduce them all to you. Firstly, as you can see, they're all there on the screen. It's so lovely to see you all. Firstly, we will have Ms. Tatavola Matas, who is the coordinator for the Vanuatu Women's Center. And Ms. Matas will speak first about the history of the Family Protection Act and how it changed the processes of obtaining protection orders from the courts. And she will also speak about how the Vanuatu Women's Center has been able to use family protection orders to protect their clients, and also some of the challenges they have faced as well. So over to you now, Ms. Matas. You have 15 minutes, ma'am. Thank you.
Thank you, William. Hello, everyone, Australia, Pacific. So, as William mentioned, I'll be speaking briefly about how the Family Protection Act has assisted women, especially women victims of domestic violence, since it came into force in 2009. So, prior to 2009, domestic violence protection orders were obtained by way of Section 16.15 of the Vanuatu Court Civil Procedure Rule, where victims had to apply for a domestic violence protection order by filing a civil claim and a sworn statement in support of the claim and a statement of undertaking to pay for damages in the event that the court finds that the claim is vexatious. And a victim had to pay a court fee of 3,000 Vatu, it's about $30. And so, yes, that was quite a challenge then. And so after 2009, upon the Family Protection Act being assented and being assented and came into force, it was much easier for victims to apply for a protection order, where a victim only needs to fill in a very simple form, basically her name and her address and her contact, and the defendant's name and address and contact, and the grounds of application, why she's applying for a protection order. And also because there's a waiver for court fees in the legislation, so there's no need for a victim to pay for a court fee. It's now free, and so that really assisted victims of domestic violence. Yes, it made it much easier for them. According to the experiences of the client of the Vanuatu Women's Center, it enabled our clients to get a quick protection from the courts. As per the legislation, the magistrate court has to treat family protection orders application as a priority. And so it assists victims in that manner. And victims take the protection order and await the criminal aspect of the case that is being processed by the Family Protection Unit and the police. And victims see it as very helpful to them for their protection. A lot of clients have reported that obtaining a protection order has changed a perpetrator's behavior. As in the past, the perpetrators were getting away with the violence because the victim has not been reporting to other agencies. But once a report is being done and a protection order is being obtained, the perpetrator fears the court and the criminal justice system. And so he takes the initiative to change his violent behavior. However, from our client's experience, there are also some perpetrators whom the same victim have applied for the family protection orders for several times now. I guess it comes down to the perpetrator and his aggressive behavior and his unwillingness to change. Our clients have also reported that the family protection orders has also, while it disciplines the perpetrator, it also disciplines the client, the victim, because the victim says that sometimes she thinks it's not domestic violence, but when she comes to understand the issue through counseling, some of her behaviors amount to domestic violence as well, and so such as hash talks or swearing or yes, some form of domestic violence. So, but she has come to learn that once she obtains a protection order, it's so Section 13F of the Family Protection Order, Family Protection Act here in Vanuatu, it prohibits both defendant and complainant from doing any acts that does not promote harmonious family relationships. So then she comes to understand that she is bound by the terms and conditions of the orders as well. So it makes the victim, yes, both parties try and live harmoniously. Also, understanding the dynamics of violence against women and girls and domestic violence, I think it is very vital for those in decision-making authorities. And so we see that training of persons in authority, whether it is police or the courts officials or any other person in a decision-making authority is very vital. And I would like to acknowledge, I know Vanuatu Police Force has done some trainings in the Pacific with the assistance of the Pacific Women's Network Against Violence Against Women and the AFP, and as well as Vanuatu Women's Center had run some trainings with these agencies. So it has, with their understanding of EVO, it has made a progress much easier. So I would, being in the center for almost 13 years now, there has been a big change from when I started 11, 12 years ago to how police and other agencies respond today. And so, yes, and also rural women in accessing family protection orders, they are able to access family protection orders through Vanuatu Women's Center's Kavau network. Kavau is Committee Against Violence Against Women. It comprises of rural women in the community and also our male advocates and our sub-centers in the provinces. So it works where if a woman or a victim is in one of the rural areas, and since the courts or the police might not be on the island where the woman is, so through the Vanuatu Women's Center network, a Kavau will assist the woman in contacting the VWC here in Port Vila or the relevant sub-center in the province where she is from, and that sub-center or VWC will assist the woman in applying for a protection order to the courts. And Also, in some areas where there is internet, a good internet connection, applications can be emailed to the courts directly to apply for family protection orders. One thing I want to emphasize is the importance of networking, and not only by the Vanuatu Women's Center and its CAVAs or male advocacy network, but networking with the police and chiefs and churches, health, education authorities, because once we all understand evil, then and understand who to refer victims to, then making an application for protection order or making a victim feel safer, it's much easier, because we do not only receive referrals from our own network, but from other agencies as well. So now we want to challenges in family protection orders. While I did mention that the police response to domestic violence and family protection orders has significantly improved in the past, but there are still certain challenges in serving family protection orders by the police. One mainly due to the geographical challenges. The police are on certain islands, they're not on all of the islands, and so there are high transport costs, which makes a service, which delays a service of protection orders. And then, yes, as mentioned, the attitude, people's attitude is also very important. So from VWC's experience, we have very good collaboration in certain provinces with certain police commanders, but in other provinces, the collaboration is not very good. It comes down again to one's attitude towards and one's sensitivity towards the issue of violence against women and girls and domestic violence. Yes, and as mentioned, courts are not on all the islands, and so it is quite hard for reviews to take place on time, reviews of family protection orders. So the current practice is that, so for example, if a court order is made February 2021, then the review of the protection order will have to wait until the next court tour to Pentecost. And that could be in December 2021 or next year, 2022. So yes, these are some of the real challenges that victims face with a reviewing of the family protection orders. So we also face challenges, as mentioned. So with the police, they are not on all the islands. So well, the Family Protection Act states that it's the police. Yes, police have the power to serve the protection orders, but because police are not on all the islands, we have there are instances where we have asked the courts to put names of persons other than the police to serve protection orders. So on islands or areas where we have our male advocates who understand evil, we ask the courts for the male advocates to serve the protection order, or chiefs, or the area council secretaries or area administrators, people who have some status or standing in the community and are respected by the community to serve family protection orders. Yes, it's not in the law, but that's what we do to ensure that the defendant is being served with the family protection order. Yes, and another challenge, courts, they do play a very important role to ensure the safety of victims, whether it's women or children, or women and children. And sometimes victims ask for a longer period of protection orders, and a shorter term is given. So sometimes victims ask for a month or 2 months or 3 months for protection order, but the courts will give 2 weeks for a protection order. And with the challenges in serving the family protection order in the remote areas, by the time police or the chiefs are ready to serve the family protection orders, the court orders has lapsed. Yes, has lapsed. And also challenges such as releasing defendants on bail who are repeated offenders. Okay, and I'm happy there will be a multi-service delivery protocol. We're working on one here in Vanuatu soon, so that will enable all agencies to work together. Thank you, William. I'll stop here.
Thank you so much, Ms. Matas. It's wonderful to also hear on the experiences of how the Vanuatu Women's Center has been able to use family protection orders to protect their clients. And also, thank you for highlighting some of the key challenges that the center has faced. So thank you for that. Moving forward, ladies and gentlemen, we will hear our next speaker, Inspector Lily Joel, who is the officer in charge of the Family Protection Unit with the Vanuatu Police Force. Inspector Joel will speak about some of the early challenges with the family protection orders from a police perspective, and also some of the recent changes in relation to procedures for service of orders that have been made improvements to service and the enforcement of orders as well. So, Inspector Joel, you now have the floor. Thank you.
Thank you, William. Hello, everyone. Since 25 November 2010, the Family Protection Unit has come to full operation, where we deal mainly with domestic violence issues. It has been reported to through the Family Protection Unit. So since 2010, we have few staffs, around 7 staffs, where we deal with domestic violence issues. And by that time, we also do the application for protection orders, as well as investigate domestic violence and serving the orders. So it is challenging for us because we do the investigation as well as the application and serving the orders. So it has come that most of the cases we do not investigate, as it is there to investigate as our role to investigate domestic violence case. So we refer the application to Vanuatu Women's Center, where to help us do the application to court. So they help us do the application, but still we investigate and serve the orders. But yet it is challenging for us that all the orders, most of the orders are not served due to cases that we have to investigate. So back in 2017, the Vanuatu Women's Center has training with the Port Phillip police commanders, and that's where we go through the Family Protection Act, and it has come to our common understanding that all the orders have to be referred to officer in charge of Vanuatu, officer in charge of police station. So from there, Family Protection Unit is no longer serving the orders. All orders that have been directed from the magistrate to police have gone to the officer in charge of the police station. But still, we find out that most of these orders are not being served. Until early this year, we found out that some of the victims have been complained to the magistrate that the orders are not being served. So the magistrate has to summon the officer in charge of police station to explain why the orders have not been served. So from there, now all the orders are well served compared to the past years. We also deal with breach of orders. Once a order has been breached, police have the right to arrest the accused based on the criminal procedure code, where we arrest them accused and deal with according to the CPC. And if the accused commit another crime, then we have him charged for the crime also that has been committed. So from area in Port Vila, in Santo and other parts of Vanuatu where Family Protection Unit is being there, also they serve orders. Santo, they still do the application and serving the orders. I think that's all from the police.
Thank you, Inspector Joel, for your enlightening remarks. And thank you for highlighting the challenges with family protection orders from a policing perspective and the recent changes in relation to procedures for service orders that have been made. Ladies and gentlemen, I know and can view from the wonderful feedback from the audience of how this symposium is going, and it's so wonderful that everyone is able to join. So I'll introduce you to the next speaker. Our next speaker for this session is Miss Polly Walker-Dorras, who is a senior police officer with the Vanuatu, Australia Police and Justice Program. So Ms. Walker-Dorras will speak about the piloting of authorized persons under the Family Protection Act and how they have been able to issue family protection orders in rural and remote communities as well. So over to you, Ms. Polly Dorras Walker-Binaka. You have 15 minutes, ma'am.
Thank you. Just to clarify, sorry, I'm not a senior police officer. I'm a senior project officer. So I'm not a police officer. I'm traditionally a lawyer, but currently working in a project officer capacity with the Vanuatu Australia Police and Justice Program. And just for context, the Vanuatu Australia Police and Justice Program is a bilateral Government of Australia, Government of Vanuatu program that commits support to the justice sector. So in 2008, when the legislation was passed and enacted in 2009, the legislation provided for the appointment of what we call authorised persons. And this is largely to overcome the geographical challenges that Vola spoke about in her presentation. When you think about Vanuatu, we've got 82 islands. We've got 2 islands or 3 islands with sort of main town centres, 4 if you include Malakula in that. But once you go out past Santo, Tana, Malakula, and Port Anefate, getting access to justice services is incredibly difficult due to the geography. And even when you're outside of those town centres, transport costs are extremely expensive, roads are not very good. So access to justice is a real challenge based on our geography as part of it. There's lots of other challenges, but geography is certainly a significant one. So authorised persons are, in the Act, individuals who live in their community. They can be a range of different positions. They can be chiefs, they can be teachers, nurses, or just people who write to the minister asking to be appointed. Once trained and appointed, they have the power to issue temporary protection orders for survivors of domestic violence within their communities. So it was clear from the wording of the Act that these positions are designed to provide access in locations where access is extremely limited. But it took a very long time for the positions to be piloted, because while they sound simple in theory, the practice of standing these positions up is actually fairly complicated, noting issues of safety, putting people on the front line of domestic violence in a remote community with no backup or support from policing services. So there was a lot of thinking that had to go through, the training that needed to be given, how we would bring these positions about, what sort of support they would be entitled to. So there was a long period of time where the Department of Women's Affairs did a lot of research and took a lot of time to think about how it could happen. And then in 2016, a formal request was made to our program to assist the ministry to establish these positions as a pilot program. So I came on board in 2017 and joined a small team that were charged with setting up the pilot program on behalf of the Ministry of Justice. The pilot program involved designing of the training program, selection of the sites and the individuals who would eventually become authorised persons. The way that the sites were selected was based on trying to identify sites with a variety of characteristics. So there were some urban sites here in Port Vila, one northern Ifate site, but 3 rural sites on Santo. And of those 3, one was particularly remote, requiring access by a truck for about 2 hours and then a 1-hour boat ride. So that was the most remote. One of the big criteria was that there had to be telephone reception. There are still a large number of villages in Vanuatu where there is very limited to no phone reception. So in order to combat the safety issues, there really needed to be access to phone reception, as well as a road and boat access to the town for police. We couldn't choose a site where they would need to be walking through mountains to get to the village. There needed to be some way that police could get there reasonably quickly if there was a safety issue for the individual appointed. In 2018, the first authorised persons were appointed by the President of Vanuatu. There were 12, and they commenced work. The program was evaluated in 2019. It was an internal evaluation with the support of an external evaluator. I should also add that one of the mechanisms that was brought into the pilot to support the safety of the authorised persons was something that we call police rotations, and that happened on the island of Santo, and it was about trying to combat some of those safety issues. So what would happen is, and we are incredibly grateful to the Vanuatu Police Force for their commitment to this program and the connection they have with the authorised persons. Every 6 weeks, 2 officers would travel out to one of the pilot communities and stay in the community for 3 nights and 4 days. And during that time, they could do awareness about the AP role, but they could also do normal policing work, or they could respond to cases that had come up from the APs, but also that chiefs might bring to them that were not domestic violence. But it really provided a regular policing presence in those communities, which was really vital for the security and safety of the authorised persons. So, and for communities who had never ever seen police in their community before, it was something quite revolutionary. So that combination of the authorised person and police rotation program was evaluated in 2019. In brief, the evaluation findings found that the authorised person services were having a positive impact on people and community life. It was found that there was a general increase in communities' members' understanding of what domestic violence is. There was an increased access to justice because while they issue temporary protection orders, the authorised persons were also providing a referral to central justice services. So they're able to claim a reimbursement under the Act. They're able to claim a reimbursement of funds used to take victims into town, for example, or to the hospital. So they were actually able to take victims, for the more serious cases, take victims into town to make reports to police. And because of the strong partnership with the police through the police rotations, there was also, obviously it wasn't perfect, but in most cases there was generally a fairly quick police response to the reports being made. So there was this sort of increase in access to justice for these rural and remote communities. It was hard to tell whether domestic violence had actually reduced because there wasn't much of a baseline, because in these remote communities, the vast majority of domestic violence cases are still handled within customary dispute resolution processes. So to understand what the levels of violence were before APs went in is very difficult. What we do know when we've done our monitoring and evaluation is that the perception of the community is that domestic violence incidences have been reduced. For example, people reported hearing less fights in houses, chiefs reported seeing less cases come to them. So there's definitely a perception that there's been a reduction. That I can't support that with data, however. For there are currently three female authorised persons. Noting that in leadership in Vanuatu's communities, particularly in more rural and remote settings, women are often not part of community leadership positions. You know, women faced perhaps more backlash than men did in this role. I think while initially people were quite happy to see a woman appointed, when it came to women making decisions in the community that affected people's rights and responsibilities, and a woman being able to come up and say to a man, you're not allowed to do this, this order stops you from seeing your, you have to stay 100 metres out. That was quite confronting for some people, and some women reported a sense of backlash and lack of support, whereas one female AP reported a real sense of, I'm now included in the community leadership, I'm making a change in terms of the perception of women in leadership roles in my community. So there was a mixed experience of women. The associated police rotations were found to have been incredibly important for the safety of the authorised persons, but also contributing to community trust and confidence in the police, and some reports of an increased perception of safety within the community. So that was in 2019. The program continues to today. However, there's been some changes. So the town sites we found where that authorised persons were not utilised. And that's largely, I think, because the Act initially envisaged that these would be more rural positions. When there's a choice of other justice services, when you can go directly to the court or the police, having a member of your community perhaps isn't seen as being as useful. Whereas in the rural and remote setting, people described it as having justice at my doorstep, being able to walk out my door, not have to pay any money, not have to take a really long trip in a truck or a boat, but actually just being able to cross the community and knock on the door of the AP's house. For rural and remote communities, it's been a game changer in terms of access to justice. However, there are challenges, of course. These are voluntary roles. There's a lot of trauma that they experience in having that, obviously, as all of you who work in this space will know, of being a frontline service provider. They don't receive any payment, and most of them rely on subsistence farming for a living. It can take up to a day of their time to handle a case, because they not only take the complaint, make the order, they are then responsible for service of the order. So they can either do that through personal service or over the phone, or sometimes they can use a chief in their community, particularly if there's a safety issue. But the amount of time it takes to find the perpetrator, explain the order to them, make sure they understand it, it can take a significant amount of time. And then if they're taking a victim into town, you can talk about 2 days or 3 days, that's time they can't go to the garden and get food. So particularly for those with young children who have school fee obligations and things like that, there's a significant personal toll that doing the work takes. And over the 4 years, in terms of the monitoring evaluation that's been happening, for some individuals, there's certainly a fatigue that is coming about, and a sense of perhaps needing greater support financially, and that's something that is an ongoing challenge, because there's challenges in making them paid positions as well, obviously from a resourcing perspective, but also in terms of whether people would be then motivated by the right reasons to take on the role. You're talking about communities where there's no other paid work, so if you introduce a paid position, it becomes quite a political issue as well. So that's been quite a significant concern. However, despite these challenges, there's certainly a strong commitment to the work, and we've seen an ongoing use of the service in those rural sites in Santo, which are now the only current active sites, continuing over 4 years. The big challenge now, so for 4 years, this program has been owned by the Ministry of Justice in Vanuatu, but implemented fully by our program, and that includes doing the training, doing the monitoring and evaluation, operating a 24-hour helpline for the authorised persons to call when they have difficulties or they need advice, providing the reimbursements for expenses. So this is a significant piece of work, but now the big challenge is how do we transition this to a fully Vanuatu government implemented service. There is an implementation partnership group that includes the Vanuatu Women's Centre, the police, the Ministry of Justice, the Department of Women's Affairs, and the Vanuatu Maori Council of Chiefs. And so that group is looking now towards a transition. We're looking to, complicating all of this is that the Ministry of Justice is also being dissolved in Vanuatu, with agencies being placed under different ministries. So the transition process is now looking at DWA as the owning agency, that's the Department of Women's Affairs, sorry. So what we've agreed with DWA is that there will be a person appointed in 2022 who will work very closely with our team to scope and explore how a transition can happen. So that's the really big challenge. We're also hoping to trial an expansion. So now that we know how these positions work and we understand some of the challenges involved in a very in-depth way, we're now looking at what next and how do we roll this out. It will need to be slow, it will need to be careful. Every island is very different, has its own customary practices, has its own governance structures. So it's not a country where one model that works here is necessarily going to work everywhere. So it needs to be quite a slow and well thought out process. So that's sort of where we're looking at to the future. And sorry, I've been a bit rushed, but that's where we've been and where we're going to. And I'm happy to answer any questions as Vola and Lily, if there are any questions.
Ladies and gentlemen, we just have 3 more minutes remaining on schedule. If there are any questions, so we'll allow for questions for the panel. If there are any questions, you can ask your questions now.
I can see one question to Inspector in Vanuatu. When there's a breach of a protection order, do police charge the offender with the offence of domestic violence or charge him with breach of an order, or both? What is the practice in Vanuatu and why?
In Vanuatu, we charge him with breach of order. Then if any additional charge, additional offence that has been committed, then we charge him with offence that has been committed.
Thank you, Inspector. Are there any other questions? We have 2 more minutes remaining, so if you have some really urgent questions to make, this is your time to also ask.
Could I jump in and ask a question, take advantage of being a host? I just wondered what the courts think of the authorised persons. Are they comfortable with the authorised persons taking on this role?
Thanks for the question. My understanding is that they are, because as we've noted, this significant geographical challenge in Vanuatu, and I can't underestimate how significant it is. I think that there is an understanding of the need, even if I'm not saying there aren't concerns, because you are giving a community member a quasi-judicial function. And certainly, there may be concerns about how that might be carried out and whether there might be overreach and things like that. I think the legislation is quite good in the sense that they can only make a temporary protection order, and it can only be for 14 days. They're allowed to extend it once for another 14 days, but that's it. At 28 days, if the victim requires ongoing protection, it has to be referred to the magistrate's court for an application. So my understanding is that there is an appreciation of the need for the service in those more remote locations, and breaches of authorised person protection orders have been prosecuted successfully in the magistrate's court in Santo. So there's certainly an acceptance that the orders have power under the Act. So yes, that's my understanding of the situation. If you two want to add. Sorry, and I've just seen another question here. How are police and authorised persons working coordinated? Are authorised persons in places where there are no police? And how are breaches of those orders addressed? So yes, authorised persons are in places where there are no police. The three sites, the three main sites in Santo, the closest one is about an hour and a bit's drive to the town of Luganville, which is the nearest police station. In terms of how they work together, I have to really commend the Vanuatu Police Force for their commitment to supporting the authorised person program through those police rotations that I explained, where the police go out and stay in the community for 3 nights, 4 days, about every 6 weeks to 2 months. So they communicate with authorised persons that way, but also we've worked very closely to train police officers so they know who authorised persons are and what they do, particularly within the Family Protection Unit. And so that when the authorised person comes with a case, so brings a victim into town, the police know who they are and understand why they're assisting the victim in coming to the police station. In terms of breach of order, it does require the authorised person usually has to bring the complainant into the police station with a copy of the order, explain the conduct that resulted in the breach, and then the police will respond following that report. We haven't had a huge amount of breaches reported. I'm not saying that that's not an indication that they don't happen, although our monitoring evaluation would suggest that largely the orders are quite respected. But where there is a breach, the police have responded promptly. So that has been really important to the position, because if there is no response, authorised persons are quite, the faith that the community have in them and their work is really affected. So it's really important that we build that relationship with the police.
Thank you, Polly, for that. I think we have another question that's been posed. I'm not sure if you were able to answer this or see this. It's a question where it reads, has there been applications to discharge protection orders in Vanuatu? And if yes, what was learned from that process?
Thank you, Catherine. Yes, usually, so when applications from whom? From perpetrators or from victims? Well, usually perpetrators seek an application to discharge a protection orders, but it is always at the discretion of the courts, and the courts must treat the safety of the victim as priority, and yes, the safety of the victim as the priority, and has to look into the previous what's the word? Into previous offences and previous offences of the perpetrator, but yes, usually applications are made but are not granted by the courts. Yeah, only if the perpetrator shows that the claim is a vexatious claim, then the protection order is being dismissed. Otherwise, Yeah, but what the perpetrator can also do is apply for an earlier hearing, for the courts to hear the case much earlier than the date put in the protection order, in the court protection order. That's what the perpetrator can do, apply for an earlier court hearing date.
Just to add with the authorised persons, there is a provision under the Act that a person can either go back to the same authorised person or to a different authorised person to request that the order be revoked. But we haven't had a situation yet, as far as we know, where a perpetrator has sought to have an order revoked. And that may be because they're such short orders, they're only 14 days, and perhaps people feel that it's, you know, well, I may as well just do what is required for 14 days rather than go through a process of seeking to have it removed. But so far we haven't had that experience, noting it's a very small pilot, of course.
Thank you so much. I believe we have another question. We have 4 more minutes remaining, so it's exciting as well that questions are coming in. We have a question from Ash. The question reads, how are the more informal or alternative systems of justice understood by the community, particularly survivors? Are they seen as more beneficial than the state, disruptive to it, or a bit of both?
Okay, Vola's nominated me to go first, and then I'll hand back to her. Sorry, I'll move the laptop screen out of the way. Sorry about that. So in terms of the views around the customary system, I think it's far better understood than the state justice system. So certainly there is a, you know, like I say, the vast majority of domestic violence disputes or cases would be resolved through approaching the family leader or the chief in that community. Most, particularly when you're talking rural and remote, there's very little awareness of the law and of formal justice systems. And our experience with authorised persons in some communities is that there has been, you know, it's kind of brought to the fore, that sort of conflict, particularly while we have to get the endorsement of the community leadership for the positions to be in place, and even some authorised persons are chiefs, but there is a sense in some areas, perhaps as they've started to become more aware of the work that that authorised person does, that, oh, is this taking away the role of the chief? Is this minimising our customary governance systems? But over time, chiefs have actually been able to work, once they understand that the AP role is actually quite limited and the customary systems still have a very important role to play in community governance, they've been able to work more harmoniously. And in fact, a lot of chiefs now refer cases to APs because our chiefs themselves, particularly those in the community, they can see the cycle of violence happening. They can see the same couples coming back to them every time, and they find the perpetrator and he does it again. And so for some chiefs, they've actually really found it incredibly useful to have an authorised person in their community that they can hand these cases to, where the community system isn't working, the community system isn't providing enough of a deterrence. But I think certainly, I mean, it's a really unique thing around the Pacific with this sort of hybrid justice system, and there are areas where they work well together and areas where there's definitely tension and a sense that you know, the formal justice system is taking away from the customary governance system. Did you want to add to that?
Thank you so much. We just have 1 more minute left, so we'll take one final question. This question is from Judy, and it's a question for Inspector Joel. Does she believe some police, Inspector Joel, I think it's addressed to you. Do you believe that some police are less likely to lay criminal charges for DV because of the option of protection orders?
By the police, but you need to put in charge from any that order, and the whole order kami ng instruction your domestic violence offense.
No, when there's an order and if the victim needs an order, and it's up to the victim. If she needs the protection order, we refer her to the Women's Center for the application. But if she needs an order and wants us to continue with the criminal charge, then we do that both.
Thank you, Inspector.
No drop policy.
And we have a no-drop policy when the statement is lodged. There's a no-drop policy where the case has to be taken to court, and if the victim wants to withdraw the case, she would have to explain to the judge why she would have to withdraw the case. But with the no-drop policy, we don't drop cases once it's reported to the police.
Thank you, Inspector Lily. We will close this session now. We've reached time. So thank you all so much to our three speakers, Ms. Tatavola Matas, Inspector Lily Joel, and Ms. Polly Walker-Dorras. It's been really interesting to hear and learn about the Vanuatu experience. Thank you so much for being present and for also giving your time to also share with us and to also share with all of us present here today. And to all our speakers that have all spoken from when we commenced this symposium this morning, I'm sure that everyone present here today have learned so much from you all. There's so much valuable knowledge to process in terms of the shared experiences and the challenges, and it's great that we have this space in this symposium to learn from each other. So thank you all so much for the marvelous work that you all do around domestic violence, protection orders, and to also ensure the efficient and effective access to justice for survivors.